All right, about to go now.
How are you doing?
Oh. Hi there, Bruno. Sorry, fine, thanks, and you?
I'm good. Did you get a good rest? Are you ready to hit this the ground running?
Well, unfortunately, no rest for me. I spent my December working. I'll luckily get a rest in about a month's time, where I sneak off to go get some cooler weather and get away from this heat that we're experiencing in Joburg.
Yeah, fair enough. Yeah, no, fair enough. So yeah, so what's that next month?
Yes, next month I'm out of here. So I'll have to substitute myself for someone else for the PLA for some time. How about you? How was your December?
You can bring Solna back. No, yeah, mine was good.
Yeah, good. Yeah, no, I'll tell Solna she has to come back. Perfect. Well, Bruno, we got two questions today. So I'm going to give the first one to you.
Sure.
This question, unfortunately, we don't have a name for it, but it was placed on our YouTube. And basically what they say is they have a cooperative housing society with limited liability and a tenant co-partnership that has 47 members and owns a plot, which is about 1,500 meters squared in extent. They have a elected management committee and a registrar as well. And what's happening there is the owner of the plot that neighbors their society basically wants them to sign a consent to a servitude of a certain meterage over the plot that they own, in exchange for a redeveloper co-owner of the neighboring plot to give them more area than what another builder can give. So the questions are: does giving signed consent to a servitude imply a dilution of the plot ownership rights of the society members? Okay. Then they're asking, is the consent of each of their 47 members required for the registration of the servitudal deed? And does the servitudal deed need to be registered against the title deeds of the property?
Sure.
And there's another question. Very lastly, what can be done by the members of the society to oppose the servitude deed to ensure that their co-ownership rights are not diluted by the servitude deed?
Okay, cool. So maybe keep track to see if I do actually check.
I promise I'll help you out. We'll go through the questions. So to repeat the first one, does giving signed consent of the servitude imply a dilution of the plot ownership rights of the society members?
So I'm going to make your life difficult, and I'm going to like answer it in a very weird circular way, right? Yeah. Well, to begin with, so most people understand. So a cooperative, if we draw an analogy to our corporate structuring in South Africa, cooperative, very similar to a company in its legal nature. So it's just something we need to remember. So we speak of societies, associations, a whole range of different things, and sometimes it causes confusion in the understanding on how these function. And a lot of them, we speak about treasurers, other ones directors, other ones CEOs, other ones CFOs. It starts getting confusing. All these words start getting thrown around. What do they mean? What do they do? What's the difference between them? So we need to start drawing analogies so that people have that basic understanding. Cooperative, very similar to a company. Yes, there are material differences, but that comes into the fundamentals behind what one does. A company is for profit. Cooperatives is for benefit of its members. Now, you'd assume, right, that a company is also for the benefit of its shareholders, but cooperatives deal more with socioeconomic issues. So they take certain communities or people in communities and they involve them in projects. So it's not just about making money and profit and trying to put money in people's pockets as one would typically with a company, but it's more about providing something more than just a profit. So for example, food, where you have cooperatives where there's 50 members and they run certain organic food programs, and it involves education, involves a usage of certain areas, and they grow their own vegetables or they farm certain animals in sustainable ways, and they're all involved and they all have a basic ownership over the process. But at the end of the day, what do they take home? They take home food. They take home sometimes money from the sale of these things to farms, you know, that sort of thing. So you do have housing cooperatives as well, especially when it comes to the affordable housing space, where there's common land that's owned, and sometimes developers get involved in this, and part of the project is to create these cooperatives to assist the local communities. So you find this especially when it comes to tribal lands and things like that, where you try to create these cooperatives, but there's no limitation. So now, so this is my understanding of the question. We have a cooperative that owns this land. So my first assumption is that it's a legally incorporated cooperative, and that there's a bunch of members, 47 members. Now, in cooperatives, typically your members, analogy, shareholders. So there's a lot of input that the members give towards the cooperative. That being said, sometimes it is very difficult, especially with larger cooperatives, where every time somebody needs to make a decision, you have to call 200 people into a room, 300 people into the room. It becomes impossible to manage. So what do? We create leaders, rather, we appoint leaders. So as an analogy to companies, cooperatives have things like directors that make certain operational day-to-day decisions. They've got treasurers, so very similar to CEOs. They've got chairpersons that run meetings. They might even have one single central person that makes certain fundamental decisions, right? So now we've got these members that benefit, and we've got a management committee like this person mentions. Now, let's get into the property side of things. Forget that this is a cooperative, because I think that might actually just complicate the issue somewhat. So there's a certain personal legal entity that owns property. Now, servitudes are basically a certain right of usage or a certain limitation that a person places on that specific property. Why? Many reasons. There's servitudes for right of ways, where the only way to get to plot A is through plot B. So plot B will have to have a servitude registered over it in order to force that right of way. And even though plot B is owned by a specific individual, sometimes it's set in stone that that plot has to have a servitude. When does this happen? When people own large pieces of land, they subdivided, and they decided, well, I want 3 pieces. There's no access to a road except from here. So when we divide, we're going to set this condition, and no one's going to be able to remove that condition as long as it's useful, as long as it's needed, required, right? So that's typically how servitudes work. There's plenty of servitudes. Government may insist, guys that used to own the property may insert the servitudes in order to make the subdivision feasible, whatever the case is. So here they're being offered, they're basically being there's a request that they give a servitude over their own piece of land to somebody else, to a neighbor. There's no specification why, but in exchange, instead of being paid a price for it or some sort of rental or whatever you want to call it, they're instead being offered more land. So all of this matters because that's where we need more information. So are they being offered ownership over more land? So now they own 1.5 thousand square meters. Are they being given whatever X amount of square meters, which they will own and be able to do with as they please in exchange for use of a servitude? Also, another very important question is, what is the servitude for? Because remember, if it's just a right of way, maybe it's not inconvenient, but there's certain things that you wouldn't necessarily want people to be able to do on your own piece of land. So it's very important to specify what is the servitude that you're being offered, and is its value the same or similar to what's being given to you? Because at the end of the day, it's a transaction. So it's quid pro quo. I'm giving you this in exchange for this. So I don't care. I'll take the servitude over my land. Doesn't bother me. I'm getting this in exchange, which is valued at X, and I can do Y with it, right? So the due diligence component, right? Because now it comes to the decision. Does the cooperative have to take it? No. Cooperative legal entity has to sign one signature to say yay or nay. But how do you get to that one decision? As a collective, you obviously need to now look at the constitution, analogy, memorandum of incorporation, same thing with a company. There's rules there on how decisions are going to be made. A lot of rules are made by the members, especially very important rules, because the members, all of them collectively, need to make certain decisions. So is this a operational question, or is it a material decision by the members? If this is the only property that's actually owned by the cooperative, I dare say it's rather material, especially considering we're speaking about 672 square meters, so it's a substantial portion of it. So my gut is telling me that this is going to be a member decision, but I might be wrong. But only the documents would tell. So yes, you would need to be able, you would need to have this conversation between the members of the cooperative in order to make the decision on whether they're willing to take up, basically to provide the servitude and take over the property or not. And then yes, obviously, so it would come down to a vote. So this is now a question: does anyone want to oppose? Absolutely. You'd have the opportunity, because they'd have to call the meeting in order to make this decision. And by virtue of that, there would be an opportunity for there to be opposition. And then insofar as registration is concerned, I think I answered that initially. There would be a requirement for a registration of a servitude against the title deed. It's really the only way to enforce the servitude. If it's not registered, then it won't work over the property. So, and it's a real right. So if this cooperative ever sells the property in its entirety, the servitude will remain. So it's also another consideration is, if there's ever an intention to sell this property, what do you do? You'd have to bear in mind that now it's subject to the servitude, which may impact its value. I hope that kind of covered everything.
Yep, you got all of the questions. You got all of the questions there. Well done.
Cool. So then the second question, and we're getting a lot of this. So it may seem like to some of the viewers that this is a very common question. Some of you might actually even be able to recite the answer verbatim, but it's still an important question because we keep getting asked this, and there's a lot of people out there that don't have the answer. And December does seem to be a very strange time when it comes to things like this, because we've received a substantial increase in this question. So Nick, there was a Vanna. Vanna was going to move out at the end of January. But then mid-month, 14th of Jan, landlord came, removed safety gates, all door locks, cut the electricity and water. And now it sounds like Van is still on the property, but yeah, so you're safe with safety gates and the door locks and water and electricity. And he has children, and you need to know what he does under these circumstances as a tenant.
Perfect. As you said, we've done this topic many times, but as it's 2023, we'll go from the very beginning again. So I'm going to assume, for the purposes of the question, that Bruno is a tenant in the particular property. He says he's moving out at the end of January. Under what circumstances, he doesn't particularly say. But irrespective, what this comes down to is what we call spoliation within our law. So it's an established principle of South African law that no individual within the law is entitled to take the law into their own hands and enforce the law without some sort of judicial oversight or a court order. Okay, so what this means is, you can't just decide that you're going to take the law into your own hands and do whatever you want, and just enforce the law in your own particular way. We have processes for this to happen, which generally involve judicial oversight to approve the actions of a person to be taken, and also to give instructions to particular individuals to make whatever steps the court wants, which is why we have the sheriff, okay, who effects evictions. So in these particular circumstances, obviously we know that if you want to get an unlawful occupier out of a particular premises, and I'm not saying that Vern is an unlawful occupier, just for general purposes, you need to approach a court. You have to get a court order. That is the process within South Africa. There's no other way to do it. Okay. In circumstances where you take the law into your own hands, it is an action called spoliation. Okay. Now, our law protects against spoliation. Our law does not want individuals to take the law into their own hands. And what Werner has said here would clearly form an act of spoliation. So what spoliation protects against is the possession that one person has of a particular thing within the law. So there's that old adage, which possession is 9/10 of the law. This is the one thing that we're talking about. The law will protect one's possession of a particular thing, okay, until a court makes a determination that perhaps they should be dispossessed of that particular thing. Okay, so when it comes to spoliation, and this is the good old adage that every attorney learns while he's at law school, that spoliation will protect someone's possession of something, even a thief. Okay, so if a thief has something, it can be given back to them. It doesn't matter. The law will protect it and give that thing back to that person until such time as a court makes a determination, says, no, you're not entitled that particular item. So in this particular case, Werner is obviously, he's in occupation and in possession of the premises. Okay, for whatever reason, his landlord has now come and removed safety gates and locks and cut the electricity and water. Okay, these are steps that are now detracting from the possession that Werner has of the property. Okay, now not all of these are, you know, he kicked him out of the property. Some of these things are incidental to his possession. Okay, but certainly the act of cutting locks or removing locks or whatever the case is, and in particular a disconnection of water, which we must remember, water is a human right in terms of our constitution. And that is something very serious to have terminated, especially as Werner says, in the circumstances where there are children on the property. These are certainly acts of spoliation, which a court is not going to approve. So what can Werner do in the circumstances? Well, it's quite simple. This is one of the circumstances, and a spoliation application is an application by its very nature that is urgent within our law. Okay, so what you would normally do is obviously you would approach attorney, or if you're not going to approach attorney, you could approach a court direct. Okay, and basically you're going to raise a spoliation application. Generally, that would involve, the first thing your attorney would do is send a letter, say to the landlord, listen, you have dispossessed our client by cutting the electricity, the water, and changing the locks. We are demanding that you restore their possession to them immediately, failing which we're going to approach a court for a spoliation order. And a spoliation order, as I say, is by its very nature urgent. So your attorney can raise a spoliation application. What they will do is they will ask for a disposal of the general rules of court, okay? And they can bring the application on an urgent basis. And when we say urgent basis, we mean extremely urgent basis, okay? I have seen these particular applications go through within a couple of Sorry about that, Bruno.
Hey, back.
I hate to use the old excuse, but yes, it was load shedding.
Oh man.
Perfect.
So where were you? Water, basic human right.
100%. So where I was basically, in circumstances where a spoliation does occur, where there's a disconnection of utilities or a locking out, or in this case, a removal, okay, you are affecting one's use and enjoyment of a particular premises, and particularly their possession of that premises that they had. And in the circumstances, what an attorney will do is they can approach a court on an urgent basis for an order for spoliation. So basically, the spoliation process is saying to the court, look, I was in possession of a particular thing. In this case, I was in possession of a property. I was using it as I was. And this person has now come and disturbed my possession of that particular property. And I want to be put back in possession of it as I was before they had taken those actions. Okay. It's very important to understand in circumstances and a lot of our clients that come with regards to spoliation, we obviously work on behalf of the landlords a lot of the time, and they say, well, this person has no right to the particular property, and they need to vacate the property. But a spoliation application has absolutely nothing to do with one's rights, and the courts will never consider rights in a spoliation application. It deals only with possession, and the court will inevitably restore possession until such time as it makes a further determination down the road whether that possession must be given up or not. But for the purposes of just keeping the status quo, they'll order this. And as I say, this can be done on an extremely urgent basis within a couple of hours if you have an attorney who's clever. And generally, it's not a difficult order if there has been conduct that Werner's talking about here. So my suggestion, Werner, if you can approach an attorney as quickly as possible, at least they can get a letter out to the landlord where they are demanding that possession is restored. You're only staying in the property till the end of the month, but a period of 2 weeks without water is simply problematic for anyone. So I'd approach attorney as quickly as possible, or alternatively, you can approach a magistrate's court to try and run the matter. The clerks at the magistrate's court are aware of these particular matters, and they generally assist people who walk in. But obviously, that's a